pronouncement of judgment, WP 18703 of 2021 and connected matters.
For the petition first. The statement. Reading response.
Judgment runs into about 120 pages, including the cast title. We have discussed various arguments, doctrines, principles, everything. Then we have come to this conclusion. It reads like this. In the above circumstances, these writ petitions succeed in the Karnataka Act number 28 of 2021 to the extent provisions we have said, not entire act is struck down. Is declared to be ultra virus, the constitution in their constitution and struck down. However, nothing in this, the consequences of striking down of the provisions shall follow. However, nothing in this judgment shall be construed to prevent an appropriate legislation being brought about concerning the subject, that is betting and gambling, in accordance with the provisions of the constitution. When a writ of mandamus is issued, restraining the respondents from interfering with the online gaming business and allied activities of the petitioner, cost made easy. The consequences of striking down the provisions shall follow.
Very grateful.
Grateful, my lord.
Sorry, I took more time.
No, my lord.
They are obliged, brother. We are obliged.
Obliged.
See that all the writ petitions
Lordships are not audible, Milan. I'm sorry.
Your lordship's voice has gone.
please ensure that all those writ petitions which have been heard and they were connected, they are shown in the judgment. The details of all those cases be shown.
Lordship, please.
Grateful, my lord.
Deeply.
Thank you.
Number one, so image ready.
The water passed by the Leonard single stage at stage level. The red petition was filed seeking for a declaration that the acquisition proceedings in respect of the additional scheduled property has lapsed. But the Leonard single stage do not observe that since section 38D has come into force, there's an amendment to the Bangalore Development Authority Act. Do not reserve liberty to the petitioner to approach PDA under 38D, but do not, however, reserve the liberty to the petitioner if it in case he doesn't fall within 3080, not come back and approach the summons court, keeping open his challenge to the acquisition proceedings. That has been done. Not if we have to consider under 3080, but there should be an admission that the land should vest in the authority. Only then, Lord, we can consider under 3080. He is not a purchaser of a property, he is an agreement holder coupled with the affluent.
There's some writ petition is pending.
Please, public interest litigation is filed challenging the amendment to 3080.
Challenge is pending.
Have you filed any interim relief application? Acha, no condolence delay explained. Oh.
There's some office objections also, Mr. Chair. There's some office objections also.
Yes, right.
Council for plant press was allowed. How much time?
4 days.
A week's time to make good the office objections. List.
Filed against the common order, my lord. The first of the writ appeals against this very same order was listed on 7th of February. And after hearing the matter at length, my lord, your lordships were pleased to admit the matter and stay the appeal order of the London single judge. Was pleased to direct the registry to place it on 8th of March 2020, my lord. Connect this matter as well with appeal number 95 of 2020.
Where that?
It was in a connected petition.
You want same order?
20%. Vivek Palla, the council accepts notice for respond number 1. You appear for the queue. So Mr. Chandramouli will take notice. Mr. Chandramouli will take notice. Shri H.S. Chandramouli, the council, Leonard Kevit, accept notice for respond number 1. Shri S. Rajshekar, Leonard AG, accept notice for respond number 2. Shri Prakash. No, Electricity Regulation Commission is B.N. Prakash. Shri B.N. Prakash, Leonard Standing Council, is directed to accept notice for respond number 3. Third, admit. Same order.
Under similar circumstances. The last portion.
Both the councils submit that in a similar matter in WP number 43261 of 2017. An order dated 28/9/2021 had been passed. The same was challenged in WA number 95 of 2022, and the said order would be equally applicable to the present writ appeal. We are the same. Registry is direct connect the above matter with WA 95 of 2022. As an interim measure, we stay the operation of the impugned order dated 28/9/2021 in WP number 43260 of 2017. The respondent shall be entitled to get the respondent number 1 shall be entitled to get the tariff at the rate of rupees 5.20 per kilowatt. Objections, if any, to be filed by 8/3/2022. Relist on 8/3/2022. You appear for. What about respondent number 2? Because it's the institution. You already entered appearance. Shishira Amarnath has entered appearance for respondent number 1. Hence, the office objection as regards non-filing of acknowledgement filing served notice on the respondent is set aside. Ready? Office objections have we removed? Want to file any objections? Then counsel for respondent number 1 seeks for 2 weeks time to file his objections. Objections, if any, to be filed before 28/2/2022. It's already admitted. He wants to file his objection. Let him.
I appear for the appellant's counsel. This respond number 2 to 6. Notice not served.
Serial number 10 wala?
Mr. Murthy, you accept notice for 2 to 6?
2 to 6 blood notice is ordered.
Who is the advocate who appeared in the trial? Notice has been issued to respond number 2 to 6, which is yet to be served. Awaiting service on respond number 2 to 6. Relist first week March. The counsel for the petitioner is also permitted to serve the counsel for respond number 2 to 6 in the trial.
Very well.
Last matter.
Interim order may kindly be extended at serial number 4.
Yes, Mr. Serial number 29 is connected, is what Mr. Krishnamurthy said.
Very well, it can be connected.
Both the council submit that the above matter is connected to UNAP 247 of 2021. Registry to connect both the matters. Interim order earlier granted is extended till next date of hearing. There's a IA, Mr. Arnaldi, for interim order.
IA is also there, but earlier I'm given to understand there is an order granted.
Section 8. You want to file any objections or you want to argue? Okay, Krishnamurthy, next time file his objections. Last week.
Interim audit to be extended.
Let appear for the appellant fifth matter.
Just a moment, Mr. Shivan.
That the court has issued notice to the
Just a moment,
respondent.
Mr. Shivan. Your matter is not yet called.
Sorry. Let appear for the appellant. Let this is against the order passed by the commercial court rejecting my application, my lord, to return the plaintiff to present before the proper court on the ground that, my lord, the suit is filed by the directors of the company against other directors, and, my lord, seeking a relief, my lord, against the directors on the ground. Allegation is that there is a misdeeds and, my lord, the misappropriation and accounts are not submitted, and on that basis, my lord, relief is sought. My lord, the defendants, my lord, have filed an application.
Commercial
On the-
Court Act. Commercial Court Act.
Section 11 of the Commercial Court Act.
Application order 7 rule. It got dismissed.
Mr. Shivarna,
Please,
can you hear us?
please, my lord.
On what grounds you are challenging the order? What is wrong?
That ground is, my lord, under section 430 of the Companies Act. Kindly see, my lord, there is a bar in respect of the issues, my lord, which could be decided by the National Companies Law Tribunal. Such a
That-
matter, my lord.
Your application
Yes,
has been rejected. Order 7, Rule 11.
Rule 10.
No, application under Order 7, Rule 11 was rejected.
My lord, it was dismissed for default, my lord, I agree. My lord, that doesn't bar, my lord, filing
You-
an application under Order 7, Rule 10.
You did not file the WS.
But I filed it belatedly, my lord, it is rejected. I am taking step to challenge the same.
Yes.
Now the question is, my lord, on the allegations of the plaintiff itself. The allegation is, my lord, by the directors of the company against the other directors, alleging that, my lord, there is a misappropriation.
Whatever it
misdeed.
is. Now the suit has to proceed.
When order 7 rule 10 says that return the claim to present before a court
Court.
Yes,
should have been instituted.
but with regard to that,
Return to
yes.
be presented before a tribunal.
But with regard to that, my lord, I have a one single judge's, my lord, the citation. Of course, my lord, it is a persuasive value of this on before this honorable court. That I filed it on, my lord, you will just kindly see. Even under Order 7, Rule 10, my lord, if it is the court without jurisdiction, the court can, my lord, say that present before a proper court. Here is a case, my lord, admittedly, on the face of the allegation.
It is not. You see the language of Rule 10.
Please,
Subject to provisions of Rule 10A, the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted.
yes.
Then how can you be permitted to take it to the tribunal?
That it could be, my lord, with great respect, my lord, of course, there is a citation of the learned single judge of this honorable court. I am trying to, Lord, rely on that, my lord, to pursue the remedy. Kindly see, my lord, filed it on 8th February 2022. My lord, that is reported in 2007 to Karnataka Law Journal, page 71. To the effect, my lord, even under Order 7, Rule 10, you can contend that, my lord, the court has no jurisdiction.
Rule 70, page 72.
That is not that. The citation, that I filed it later, that is on 8th February 2022, along with the memo. Relevant, my lord, the para 5.
That was in special circumstances where there was a bar put.
Suit was filed in that case, my lord.
That after coming into Waqf Act of 1995,
Yes,
new act creating bar of jurisdiction of civil court.
please, ma'am. But here is also, my lord, the Companies Act, section 430, my lord, says that the civil court bar is there. Even under the Commercial Courts Act, section 11, my lord, says that if it is a bar under the any other act, this suit cannot be entertained.
That you would have to file a 7-rule-11A application, Mr. Shivan, not in a 7-rule-10.
Of course, my lord, that could have been the,
And
but
what
my lord,
what the court has said is that there are a personal claim against the defendant, not just under mismanagement and.
that now the issue is go to the jurisdictional issue.
That order has not been challenged.
7-rule-11.
There has not been against that order, they would have filed an appeal. So that can be taken in order 7-rule-11.
Penalty as well.
है ना? चलेगा नहीं भाई. You could have challenged the order passed under order 7-rule-11.
Yes, my lord, I could have challenged. But my lord, with great respect, my lord, that doesn't.
Do not
want
bring
the-
that under this order 7-rule-10.
That's what the court says at any stage of the proceeding. If it is brought to the notice that, my lord, the court which has entertained the suit has no jurisdiction, barred by another law, that is the Companies Act.
So
Even
go and
under
file
the-
an appeal. Go and challenge that order. Still, you can challenge it in appeal.
You want to do that, Mr. Shivan, or you want an order on merits?
Why we should give liberty?
But I would like to challenge that order.
Like any observation that the appeal would be maintained. Delay.
Arguing something.
In fact, that was dismissed on the ground of default, not on merits. Order 7, Rule 11
They could have moved
application.
an application for recall. Case for recall is there. Case rest is. इसको तो खारिज कर दो.
The above commercial appeal has been
Sir,
filed.
in quota number 1, serial number
Challenging the
6, sir.
order dated 6
Then
September
I think
20.
8 ಅಲ್ಲಿ ಮುಗ್ದಿರ್ಬೇಕು ಸರ್ 16 ಅಲ್ಲೂ ಮುಗ್ದಿದೆ ಅನ್ಸುತ್ತೆ.
Commercial OS number 3468 of 2018 by the 83rd Additional City Civil and Session Judge. By way of the said order, an application which had been filed by the appellant herein and order 7 Rule 10 came to be rejected. In the said application order 7 Rule 10, the contention raised by the appellant herein was that the suit as framed was not maintainable before the commercial court, is barred under section 280 and 430 of the Companies Act 2013 and ought to have been filed, proceedings ought to be been filed before the National Company Law Tribunal at Bangalore. The trial court, after considering the matter by the aforesaid order, has dismissed the application by holding that an application under order 7 Rule 10 would be maintainable only when a suit has been filed in the wrong forum, inasmuch as the suit ought to have been filed in a different court, but has been filed in a wrong court. In the present case, what is sought to be contended by CH-1 learned senior counsel is that instead of a suit, a proceedings under the Companies Act was maintainable before the National Company Law Tribunal, and not that a suit had to be filed before any other court. And as such, dismissed the application, holding that order 7 Rule 10 was not applicable. Correct. We do not find anything wrong in the finding of the commercial code, inasmuch as order 7 Rule 10 provides for a claim to be returned, to be presented to the court in which the suit should have been instituted. And the procedure thereof has been provided under order 7 Rule 10A, wherein the court returning the plaint is required to indicate the court in which the plaint is to be presented and the time period in which the plaint is required to be presented. In the present matter, even if the application were for a moment considered to be maintainable and the plaint were to be rejected, the said court could not have directed the presentation before the tribunal because the tribunal is not one which is contemplated under either Order 7 Rule 10 or Order 7 Rule 10A of the Code of Civil Procedure. Thus, an application under Order 7 Rule 10 is not maintainable. It is also of significance to note that on earlier occasion, the appellant had filed an application Order 7 Rule 11D of the Code of Civil Procedure contending that the suit was not maintainable since it's barred by law. However, the said application has been rejected, though of course for non-prosecution. They said order has attained finality and has not been challenged. In view of the same, an application under Order 710 not being maintainable in the said circumstances, we find no infirmity in the order of the commercial court in rejecting the said application. There being no grounds made out in the appeal is dismissed at the stage of admission itself.
My lord, I am the complainant, my lord.
Recalling. It's a contempt. She has filed for recalling.
My lord, I am the complainant, my lord.
Yes, madam. Yes, madam.
My lord, my land was acquired illegally and without authority of law by demolishing my 3 floors of my nursing home, my lord, on 4/4/1998. I did not pay the compensation till today. My husband died at the age of 51. Even after 21 years of his death, they have not given, my lord.
You are party in
And I-
person. What is
Yes,
your
ma'am.
matter pending here?
My lord, LAC is the award and compensation awarded for the
Forget
land.
about everything. Come to the relevant. Is there any
MFA is
application pending?
MFA has been
any-
dismissed on 23/12, my lord. MFA is dismissed for them for the accused corporation filed by the accused corporation, my lord. That I have produced, my lord.
Contempt
Because there
petition
was
has been decided. Now,
yes,
have you
ma'am.
moved any application thereafter?
Yes, my lord. Yes, my lord. I moved the application, my lord. MFA were
Where is that?
dismissed. I have moved the application before the LAC court also, my lord. That executing court, my lord. I have filed the executing petition.
We are not executing court. here your contempt petition was disposed of.
Yes, my lord.
Now, after disposal of contempt petition, have you moved any application which is pending?
Yes, my lord. Recalling
Where is
application.
that?
It is with
Please take
the
out the
petition.
application. if any.
I have filed a recalling application.
Your recall is pending.
Yes, my lord.
That is to be considered.
Yes, my lord. My
What
lord,
is
it is
the-
already 25 years, my lord, and they
The
have not
order-
paid the
Order
compensation.
is on merit. Order
my
is on
lord.
merit. How your
Yes, my lord.
application would be maintainable?
Yes, my lord.
Order, your application is not maintainable.
My lord, the
Order is
appeal
on
filed
merit.
because of. Yes, my lord. My lord, the stay was granted in MFA, my lord, and therefore the
Forget
earlier
everything. Please, if you know the legal position, only then argue. We will not go on the facts of the case. Your contempt petition was disposed of by order dated 16th of April 2021. You have moved the application for recall of this order. The order 16th April 2021 was on merit. Now, how your application is maintainable? This is what we are asking you. But
Yes,
if
my
you
lord. I will tell, my lord.
look, if you'll waste the time of the court, we will impose
My
cost.
lord.
We will impose cost. Appearing party in person doesn't
My
mean
lord,
that
I
you
will read
use
the
the time
order.
of the.
I will read.
Your application is not maintainable.
My lord, executing court may be directed.
No direction can be issued by this court.
Executing court
In
may be
contempt
directed.
petition. No, sorry.
My lord, there is non-compliance of the order. They have not paid the compensation till today, my lord. In view of the Supreme Court order, the Supreme finality was reached in Supreme Court, my lord. I have produced the court order, my lord. Supreme Court order I have produced, my lord. On 6/2/2012, the accused corporation had been to the Supreme Court, my lord. The Honorable Supreme Court passed an order to pay compensation and interest, my lord, on 6/2/2012. I have produced the list of authorities, my lord. In spite of that, they have not paid the compensation till today, my lord. There is violation of Article 215, my lord.
He doesn't know.
The application in the pending MFA.
No, my lord,
3422.
MFA is dismissed, my lord. MFA is dismissed, my lord. MFA have produced, my lord. The certified copy I have produced. MFA is dismissed, and MFA for me is allowed on 23/12/2021, my lord.
Go and move an application before the executing court.
My lord, I moved the executing court, my lord. She rejected, my lord. The Honorable Justice rejected, my lord.
Go and challenge that order.
Not reject for giving the dates, my lord. Memo for posting I had filed, my lord. She has rejected, my lord. Because 14 persons, they were not allowing, my lord. Already 2 years over, my lord, since I filed the execution, my lord.
We are rejecting your application. It is not maintainable.
My lord, there is a Supreme Court order, my lord. Please, my lord, kindly direct the executing court at least to execute within 1 month, my lord. It's already 25 years, my lord.
Sorry, that cannot be done here in these proceedings. If you want that, you will have to approach the appropriate forum.
There was a direction by the earlier contempt, my lord, to pay compensation, damages. I have produced before your lordship, my lord.
All right, we
There
have
was
heard.
an earlier
Thank you.
contempt.
All right, now please keep quiet. We are passing the order. Yes.
IA-1 of 2022 has been filed seeking for recall of the order dated 16/4/2021 passed in the above matter. By said order, it has been categorically stated that in the event MFA number 3442 of 2020 were to be disposed and the stay order staying the execution proceedings vacated, then the complainant moved the execution petition and the executing court was directed to decide the same in accordance with law as expeditiously as possible. IA-1 of 2022 has now been filed on the ground that MFA has been disposed, and since there's no compliance made, the contempt proceedings have to be revived and the officers punished for such contempt. Whereas the execution proceedings having been already filed, seeking for compensation amount to be made available to the petitioner, do not lie now for revival of the contempt petition as observed by this court in its order dated 16/4/2021. The petitioner is however at liberty to move the execution court for execution of the judgment in accordance with law. The executing court is directed to dispose of the matter as expeditiously as possible.
Petition, but it's appeared that respondent has not been served, my lords, and I need 2 weeks, 2 days time to carry out the amendment, my lords, physical amendment.
Counsel for the petitioner prays for and is granted 2 weeks' time to carry out physical amendment, awaiting service of notice on the remaining respondents, relist March 1st week.
Number 8.
Certain office objections are there.
The objection is regarding the production of photograph, my lord. They are produced by the other side. Therefore, I don't have the original to produce color photographs. I made that submission.
See, objection number 1. I.e. complete copy of annexure B1 page not forthcoming to be furnished in both sets of writ of plea.
That we have attended.
You've done?
That was an earlier objection that we have attended.
देखो.
Page number, Mr. Madhu, Annexure B1. Page number of Annexure B1.
174 photographs.
No, Annexure B1. The first objection is that complete Annexure B1 is not forthcoming.
Page 94.
Still not been attended to, Mr. Patil. It says 1 of 3, so page 2 and 3 are not there. See at the bottom, it says page 1 of 3.
The order is only my rejection order that is produced. That is what was produced before the learned single judge also.
According to you, this is what was produced. Only 94 was produced.
Yeah, only 94 was produced. That is the application.
समझ में नहीं आता what is it.
Page 1 of 3. So there must be 2 of 3 and 3 of 3.
My filing of application, we produce.
Page 2 and 3. Not 1.
Okay, it says 1 of 3. Saying 2
Huh.
of 3 and 3 of 3 is to be there.
Go to this is only the odd copy of document. Page 94, you see?
Please.
At the bottom, it is page 1 of 3.
Yes, no, page 1 of 3.
And this is the objection. Page 2 and
Objection
3
is
not
that
forthcoming.
what was produced before the learned single judge in the writ petition is also only this page to show that.
You
an
understand,
application-
you are the respondent, you are the petitioner and you are the applicant.
I was the petitioner. I had produced only.
The complete document you did not produce before the writ court. Now this objection has been raised.
If I have to produce something more than that, then it will have to be by an application.
At least show if you have got the document.
See, actually, online application that is filed. Actually, that may not have any bearing with regard to subject matter, my lord, if I could request your lordships to other the matter without reference to that, my lord. The order that was challenged was at annexure page 126, annexure H. Translation is at page 128. Instead of passing an order under 321(3), a demolition order was passed. As this was not under 321(3), I could not have filed appeal. I approached this honorable court by filing a writ petition, challenging the order at annexure H. An order of demolition was made. Matter came up on 15/11/21. Notice was ordered. On 29/11/21, respondents appeared and filed objections. On that day, matter was heard, orders were reserved. On 20th December 21, order is pronounced. The learned judge, in a way, expresses his anguish. Unfortunately, it happened to be in my petition Now, kindly see the operative portion of the order. Page 50.
If you are agreed by the cost,
No, not cost, my lord. Next one. Cost is also, my lord, I would submit in a, the corporation shall take the impugned order dated so and so to logical conclusion, bearing in mind the observations made in the course of this order, saying it should be immediately done, etc., are the observations. My petition, at the best, if the Lemon single judge were to hold, it is an order under 321(3), you have alternate remedy, I would have gone there. If you were to hold, all right, even without alternate remedy, I am dismissing your writ petition, yes, I would have been there. Now, because of this order, day before yesterday, half the building is demolished. In my petition, an order,
even if we made any observation, that will not help you now.
half the building is demolished.
If we give you liberty to file an appeal,
No, half the building is demolished and the remaining portion, yesterday they have given a notice. Because I'm residing there. Unless you vacate it today, we will do it with a answer.
modify to this extent.
Mr. Patil, here you don't even have a building license. For 321, it should be a violation of the license.
For that, your worship, kindly see Sarah 12. Lemon judge finds, despite of repeated application, corporation officials have not even taken care to pass an order on the application for license.
That will not give you any right.
No, that will not give me a right, I understand that.
You are not applied. You are not applied for a license.
I have applied, release the application.
Difficulty is that even if there is some inaction on their part,
Immediately,
that
after 30 days, he should have gone to standing committee. He somehow, probably he did not have a lawyer to advise him at that stage.
the only thing is that we can dispose of this writ appeal, saying that you may avail the statutory remedy under 323
But the
and the
direction,
observations made by the court while dismissing the petition may not come in your way.
because almost half the building is demolished.
That is-
the
that is
remaining portion I would be
only-
able to say by filing an appeal.
At the most, only this much can be done at this stage. Otherwise, there is nothing wrong.
Of course, I understand, my lord, but kindly see the situation that I was put in. It was not a case where court had granted stay pending for 3-4 years to levy a cost
All right, all
of
right.
50,000.
Heard. Mr. Patil, the senior advocate, appearing for the appellant. This intra-court appeal has been filed, challenging the judgment and order dated such and such, passed in writ petition such and such, whereby the writ court, after hearing the appellant of the petitioner, has dismissed the writ petition with a cost. With cost. The senior advocate appearing for the appellant submits that the state court has not only dismissed the petition with cost, but has provided that the respondent corporation shall take the impugned order dated 9/11/2021 to its logical conclusion, keeping in mind the observations made in the writ petition, and as such, in compliance of the same, the authorities of the corporation have immediately taken action to demolish the building in question. And yesterday, half of the building has been demolished. First off, it is not in dispute that the building in question has been constructed without proper license from the competent authority. It is the case of the appellant petitioner that the appellant petitioner had applied for grant of license under section 315 of the Act, which remained pending with the corporation, and no decision was taken.
No decision was communicated. no? In the
Was
objection
communicated
statement,
was
what is-
communicated to the appellant petitioner. It is also submitted that the appellant petitioner has a remedy of challenging the impugned order passed under section 321 by filing an appeal under section
443A.
443A of the, what is that act?
Karnataka Municipal Corporation.
Karnataka Municipal Corporation Act 1976. In case the appellant is given liberty to file the appeal, the appellant would be satisfied. However, the observations made by the writ court may not come in the way of the appellate court while considering the appeal of the appellant petitioner. First off, be that as it may, be considering the peculiar facts of this case and the prayer made by the learned senior advocate, we dispose of this appeal at this stage with liberty to the appellant petitioner to file an appeal challenging the impugned order 9/11/2021 before the appellate forum. In case any such appeal is filed within 10 days from today, the appellate authority shall consider and decide the same in accordance with law. It is open for the appellant. It is open for the appellate authority to consider the question of limitation while considering the appeal, if any, preferred by the appellant. However, while considering the appeal, the appellate authority shall not be influenced by any observation made by the writ court in its order dated 20th of December 2021, passed in writ petition 20333 of 2021.
May I make one request, till 10 days or the 15 days, let them not proceed with further demolition only.
No, nothing. For that, you will have to file an application in the appeal.
We will file the appeal, my lord. The difficulty is yesterday, day before yesterday, they have issued a notice that within 24 hours, if I don't vacate, they will proceed with the
You
demolition.
file it immediately with an application.
No, even if I have to go to Shumoga and file it today, my lord, it may not be possible to save the building.
We have not entertained. We have not entertained the writ appeal. We have only, on your request, disposed it off, giving you liberty to file the appeal. That is all.
Number 9, Rajshekar.
I pay for respondent, my lord.
Commercial dispute between two real brothers. Elder brother will not filing a suit against the younger brother. Residing in the very same house in the very same building.
From where you start, we just are not able to cope up with you. All of a sudden, you start from somewhere thinking that the court knows everything and the court knows nothing. Yes, what is the matter?
It's a commercial dispute filed by elder brother against the younger brother. Contending lords, there is a liability of 2 crores, 86 lakhs, 145. That is the claim made before the lords commercial court.
Who appears for respondent?
I appear for respondent, my lords.
Yes.
I pray for 2 weeks' time. My client wants to engage the services of senior counsel. I just recovered from COVID positive, my lords. Just I pray for 2 weeks' time, my lords.
On 28th of January, a matter was taken up. Yes.
Yes, my lord. I was under quarantine because I had tested positive. Just I have recovered, my lord. I am unable to go and see the senior counsel, my lord, because of my COVID. This one.
Who are you, appellant?
I was the defendant, my lords, in the commercial suit. Decree is passed, my lords, solely on the ground that the statement is not filed.
You appear for plaintiff or defendant?
I appear for plaintiff, my lord.
What has been done by the commercial court?
The
suit has been decreed.
Decreed, my lord.
I would invite my lord's kind attention to page number 74.
Page 74.
74.
Yes. What is the ground of challenge?
My lords, per se, it is not a commercial claim at all. It was not a commercial, there was no commercial debt as on the date of my lords when the petition was made. When there is no commercial debt, my lords, the commercial court could not have entertained, my lords, a commercial dispute under the provision of the commercial court.
This you are saying for the first time before this court? This you are saying for the first time before this court?
Since my difficulties, I had not filed a written statement. The settlement process was on between the brothers. There was a series of litigation. And my lords, the terms of the elders had advised not to precipitate the matter because apparently, my lords, a tax invoice was produced. A created tax
Whether
invoice.
notice was issued to you or not?
Please.
Why you did not file the WS?
Since there was a series of litigation between the brothers, my lords, the parties are at the
Now,
elders
at the appeal stage, you cannot take this ground. If you had to take this ground of maintainability, then you had to take it at the first stage.
The clear facts, my lords, is that it was between two real brothers. That was the only.
Is there anything else or that is all?
My lords, I would kindly invite my lord's kind attention to come to page number 74.
Yes.
Defendant appeared through to their counsel on so date but failed to fail written statement. That is one. Thereafter, plaintiff was examined as PW1 and exhibit P1 was marked. And my lords, order sheet to exhibit P1 was a photocopy of my lords, a tax invoice. That document was objected and that document was marked subject to objection. That is the only document marked. Further examination in GPW was deferred on so and so date. Thereafter, PW1 was absent on 2 occasions. In fact, thereafter, PW1 never appeared before the court. Thereafter, due to closure of courts, the matter was not taken for recording of evidence till 25/1/2021. On 25/1/2021, the PW1 was absent and the advocate for the plaintiff died. At that time, I have passed an order to take the matter to dispose of under order in Rule 10 of CPC, since there is no defense with the defendant. Hence, I proceed to pass judgment and so on under order in Rule 10 of CPC.
Order 8,
I heard the arguments.
order 8, Rule 10 में.
लेकिन if written statement is not.
We will adjourn the matter on the request of respondent.
Submission given on the earlier occasion, defendant will not see respondent or undertaken not to precipitate the matter. Then may not see if that would continue.
Is there anything in writing that we are not party to that? Request of Srimati Rohini
Yes, my lord.
for the respondent, as she informs that a senior advocate is to argue in the matter on behalf of the respondent.
Yes.
Full stop. In the order dated 22nd of December 2021, Srimati Rohini KM, counsel for respondent, had stated that the respondent has not initiated executive proceedings. In case the executive proceedings have not been initiated by the respondent, then the respondent shall not initiate executive proceedings the next date.
Yes, my lord. That's obliged, my lord.
313.
My lords, in this case, I appear for respondent number 3 and 4, my lords. My lords, in this case, I appear for respondent number 3 and 4.
The appellant in this matter.
I request for a 10 days time to file my counter to the application for stay, my lords.
Lord, at their request, it is posted to today.
Change हो जाएगा.
I am for the respondent number 1, your lordship.
मेरे सामने है तो then it should be.
Placed before a bench of which one of us, like the name of brother, not a member, after obtaining necessary order on administrative file from the Chief Justice. Same order, serial number 11.
Number 12.
Serial number 11.
Yes.
Not before this bench message.
Number 12. Respondents have submitted a draft notification, my lord. Second qualification of the pharmacy inspector.
Yes, what is the position? Notified or not?
Instructions, Lord, it's not yet been notified.
Huh?
It's not yet been notified, Lord, it is pending. Cabinet approval is done, but it is to be notified, Lord, that has not been done. Meanwhile, Lord, in compliance with the directions issued by this honorable court on 18/11/2020, we have passed an order permitting appointment of.
On the last date, that is 14th of December, you informed that cabinet approval has been obtained and now file is before minister concerned for signature. The rules would be notified shortly. What is to be done now? Shall we summon your minister?
We have communicated, Lord, the orders passed by this honorable court to the authorities.
He is not exempted, he can be summoned. We will summon your minister. What to do? If the situation is like this, that the government is not functioning, not working,
Convey, Lord, just Lord,
we will summon him. More than about 2 months. Huh? So let the matter be brought to the knowledge of the chief minister. Huh? Shall we observe this?
Lord, the kind of give to your lordships, Lord, but things are not happening the way we expect.
Yeah, by God, what is the
Team matter, my lord.
I get instructions, Lord, we can have it next week.
court-wide order dated 14/12/2021 had passed the following order. Order. Learned AGA, on the instructions inform the court that still the file is with the minister concerned for signature and signatures have not been obtained, due to which the rules for qualification of pharmacy inspectors have not been notified. We take note of the fact that 2 months have passed, but due to lack of signature of the minister concerned, rules have not been notified. 2 months, no more than 2 months. When the rules were framed, when the cabinet approval was obtained, we take note of the fact that for considerable long time. The matter is pending regarding the issuance of rules for qualification of pharmacy inspector. Way back, full stop, way back on 20th of April 2021, the additional government advocate had informed the court that draft rules have been framed and would be placed before the assembly in the next session. Subsequently, it was informed that the draft rules have been approved by the cabinet. Now the file is before the minister concerned for signature. This fact was noted by the court wide order dated 14/12/2021. Still, the said rules have not been notified as the signature of the minister concerned has not been able to be obtained on the file. Let the matter be placed before the Honorable Chief Minister. बाद में दो हफ्ते बाद
Leads to safe and secure way for Asiatic elephants in Nagarabade for wildlife reserve. Honorable Court was pleased to direct the state in the past occasion to install rumbling strips in the 11-kilometer stretch, which is.
What has happened before the apex court? It is informed by counsel for the petitioner as well as counsel for respondent that the issues in this petition are pending before the apex court. Is there any detail of the SLP, anything in which it is pending? Adjourned list after 8 weeks.
Appear for the petitioners, my lord. Petitioner, my lord. My lord, I filed the amended petition, my lord, on 10th, my lord. But there was a mistake, my lord, from my side. There was a mistake.
Office objection.
Kindly grant me one week's time, my lord. I will comply, my lord.
Counsel for petitioner as far as allowed 2 weeks time to make good the office objection.
Grateful, my lord.
I appear now for the respondent to High Court administration.
Petitioner, my lord, this is High Court salary.
I appear for the fourth respondents council.
Now, the state government was to not make a submission.
You appear for?
I appear for the High Court.
The Advocates Association of the High Court. Unit High Court.
High Court unit also included. We are saving with the state bar council, but that apart, we have independent submissions. I pray for short accommodation, but hear us and then pass it. Anytime. Today, Lord, I'm sorry.
Yes, Mr. Kumar appears for whom?
I appear for the Bar Council, Karnataka State Bar Council. We have filed
What is your stand?
we have placed the matter before the Bar Council.
We need your good services.
We will get back to the court. We need a month's time. We are deliberating on it. In the meanwhile, we have also put in our statement today. I request the court to kindly adjourn the matter by 1 month. We are vigorously pursuing. Court may kindly recollect.
There is no adversarial litigation in
I
this.
respectfully agree.
It is for the better functioning of the court that we need the cooperation of all of you, particularly the senior advocates, and only with your help and cooperation we can sort out this problem of a space crunch. So,
sir, we are fully aware of the magnitude of the problem.
yes, if you want the High Court to function in a better manner and have the at least sufficient space to keep its files and the courtrooms are able to work, then you all shall come forward and give your good suggestions so that we will be able to just sort out this issue. So it is good that now the Bar Association has also joined the issue.
Please.
We will welcome their coming, and we will have the matter after 15 days. And
please make it 1 month. So because
one month, then 1 month thereafter, there may not be sufficient time before the summer vacations.
No, the reason is the learned Advocate General, who is also ex officio member of the Bar Council, it is his services we are banking upon.
We will request the learned Advocate General to please help in sorting out this issue, so that his availability would be there.
In fact, if I may say so with respect, it's only the government which can, because the
Yes.
kind of space that is required, it's a huge space that is required. And
No, it is a heritage building. We cannot make major alterations or any construction in this. The only thing is that whatever building is available, that can be put to better use. And in addition to that, we may make some minor alterations, some temporary construction and all those, so that some space is taken out.
if I may say so with respect, it is because of the heritage character of this building. This building was saved. Otherwise, it was to be demolished. It was a PIL which saved this building and enabled annex to be
our endeavor would be that we may take out some space in this building itself, because this location you will not get anywhere else.
Well, I'm sorry, Lord, I was too.
Government will definitely very easily agree to give you land somewhere else.
Please.
Well, I was to appear. I'm sorry, Lord. I just logged in late. There's some difficulty. Yes.
So we are just making a request to you,
Yes,
Advocate General, that you also come forward with your suggestions with respect to sorting out the issue of space crunch which is before the court?
Lords, we have received some suggestions, Lords. We held a meeting with the Department of Public Works Department, Lord.
Yes.
But if subject to what Lordships would say, Lord, I felt, Lord, it would be appropriate to have an administrative meeting with the Honorable High Court, Lords, on the administrative side.
We can
along
do
with
that.
the,
We can do that.
Yes, one of these days, Lord, there are about 3-4 options we have worked out, Lords, but subject to acceptance by the Honorable High Court on the administrative side. I thought next week, Lord, if Lordships are to direct one meeting with the High Court Building Committee, Lords, or whoever Lordships directs. From our side, Lord, I will in fact request the minister also, Lord, concerned to be there, along with the concerned officials.
All right, today we are adjourning the matter for 2 weeks.
Yes.
2 weeks. And since the Bar Association has also moved an application for impleadment,
yes,
and it is not before us, and Mr. Kumar has put in appearance on behalf of the Bar Council, and he also wants an adjournment. So we will adjourn the matter for 2 weeks. In the meantime, we will consider your request to have a meeting on the administrative side.
Yes. In the meanwhile, if Lordships could direct on the administrative side to us, then we will organize a meeting.
Mr. Prabhu informs that an application for impleadment has been filed on behalf of the Bar Association. How the same is not on record, office shall trace the same and place it on record. Mr. Kumar, Learned Senior Advocate, has put in appearance on behalf of the Karnataka State Bar Council. He has made a request for adjournment. Just give a date after 2 weeks. The Learned Advocate General informs, submits that a meeting may be held by the High Court on the administrative side with the representatives of the Karnataka State Bar Council and the Karnataka and the Bar Association, along with the state government on the administrative side. The request of the Learned Advocate General would be considered. Give it.
3rd March.
Please.
Number 16, Sunil Kumar.
Appear for the petitioner, my lord. This is with regard to the non-completion of the flyover project, my lord.
What do you think? Yes. Why you have engaged such a senior advocate who is not available? Huh? Adjournment is never sought on behalf of the senior advocate. He is arguing counsel. He is engaged to argue, not that on his request, on behalf of him, you can make a adjournment request.
But in fact, if my lordships kindly see, my lord, the statement of objections, my lord, filed by the BBMP, they've already written a letter to the government seeking termination of the tender to the 4th respondent, my lord.
We will have it after 2 days.
Please.
Thursday. Adjourn on the request made on behalf of second respondent on Thursday. That date.
Please, obliged.
They made the compliance. This is what they say. All right.
17.
Like wait for 2 more weeks and come.
Hmm.
Draft SO is ready. 2 more weeks.
From December, they have taken time. Case where absolute violation of the constitutional mandate and the constitution then judgment of the Honorable Supreme Court. All the panchayats, Jilla and Taluk panchayats in the entire state are under administrators.
You have not filed a statement of objection.
Draft is ready, but I need to get the approval of the
How many? Learned AGA pays for is allowed. How much time? 2 weeks and no more further time. To file the statement of objection, failing which the imposition of cost would be considered on the next date. Give it.
Number 18.
You appear for? Hmm? Who is respondent number 1? He has moved an application for impleadment. Do you have any objection on that? Will allow that application. Heard on IA number such and such. For impleadment. Whom you want to implead? Whom you want to implead?
I want to implead the Ministry of Consumer Affairs, Food and Public Distribution, my lord.
The petitioner applicant wants to implead the concerning Ministry of Food and
Ministry of Consumer Affairs,
where you have
Food
been?
and Public Distribution.
Consumer Affairs,
Food and Public Distribution.
Food and Public Distribution as respondent number 3. The counsel appearing for respondent number 1 does not have any objection. The application is allowed. The petitioner counsel is permitted to carry out necessary impleadment in the area of parties within 1 week from today. You will take the notice of newly impleaded party. The notice of the newly impleaded respondent shall be served on the counsel for first respondent. With corrected matter, respondent number 4.
Number 19. Rakesh.
Develop the license.
Hmm?
Stone crushers license. In year 2013, he obtained the license for 10 quintas of land. He is running the stone crushers in the 10 quintas of land. But he has filed the application for renewal of the license. The issued endorsement. Saying that the land has to be, remaining land has to be converted for the non-agricultural purpose. But we have also applied for the conversion of the land, my lord. In the meantime, my lord, for making the application for conversion of the land, my lord, we have to submit the levy sketch, my lord. That is the resolution made by the government, my lord. Annexure C is the resolution, my lord.
Yes.
But what is challenge is not the endorsement produced at Annexure E. Annexure E is it is issued in pursuance of the decision of the licensing authority, against which large statutory appeal is available, which he has not exercised. Under section 15, large, he has to file an appeal.
There's appellate remedy provided. There's appellate remedy provided under section 15.
Not, in the meantime, what has happened, the notice has been issued, stating that the power will be disconnected.
You have an appellate remedy. You can't send everything to the High Court. You'll have to go there. What do you want to do? Observe that and the appellant is before this, the petitioner is before this court for the following relief. Shri S.S. Mahendra, Law and AGA submit that there is alternative efficacious remedy of an appeal available to challenge the impugned endorsement at Annexure E to the. Faced with the above situation, learned counsel for the petitioner seeks for permission to withdraw the above petition with liberty to file the necessary appeal. Reserving such liberty, the appeal, the petition.
Till then, this petition may not be disturbed.
You file it immediately and seek for reliefs. Reserving such liberty, the petition stands dismissed. You don't have anything there.
I appear on behalf of the petitioner. Challenging of a petrol pump which is right next to the school. We are challenging a petrol bunk lot which is being set up right next to a school. Under the Central Pollution Control Guidelines.
Who are you? Who are you?
I'm not an RTI activist.
Activist?
Please not.
That petrol pump dealer is not giving you petrol.
But he is setting it up in contravention to the CPCB guidelines, which I have produced.
How you are bothered? How you are bothered? Your school is not aggrieved. Your school has not come here. How you are bothered that it is adverse to the school?
Lord, if anything would happen there, there are innocent students, Lord, who would.
How much cost should be imposed?
Lord, I would only say, Lord, that the petrol bunk on the very face of it, Lord, it is being set up illegally.
Yes.
Because the guidelines provide, Lord, your Lordship should see at page 46, citing criteria of retail outlets.
Where do you reside? Where do you reside?
Lord, I do not reside in the area, Lord, but as soon as I came to know this, Lord, I thought that I should be taking some action. I'm sorry, Lord, I'm only working towards the welfare of the community, Lord. Ultimately,
Which community? Which community? Which community welfare you are concerned about?
Lord, I would only see, your Lordship, you kindly take a look at page 46, Lord. Because there is an express bar in setting up a petrol pump within 30 meters of food. Lord, even otherwise, Lord.
The establishment of petrol pump is
school children, Lord.
Yes, that the school children or the school can be adversely affected because the establishment of that petrol pump?
Lord, there could be a situation where there could be a gas leakage and then there could be a fire at the school as well, Lord.
Yes.
Only to avoid something
All
that
right.
I trying to look at 46, Lord, for a
All
moment.
How much cost should be imposed on you for wasting time of the court for filing this frivolous petition?
Lord, I would only say, my Lord, that I'm working towards the welfare of the community at large, my Lord, and so that there is no adverse thing that could happen to the school. The Lordship, can you look at these
Community at large also requires petrol pump.
Lord, I understand, my Lord, but the
One of
petrol
the essential thing.
I
So
understand, Lord.
then you cannot say that the community does not want the petrol pump. That is why we asked which community or
We
whom.
definitely need the petrol pumps, Lord, but those petrol pumps are to be
The
put up in
maximum time, the time you consume, the cost will keep on increasing.
I would only request my lords to see page 46 for a moment, because what is there in this is not followed, my lord. That is my humble submission. Then I would leave it to your lordship.
No. If you want, you may argue the matter and pass the order. We have only said that we do not find it a fit case to grant indulgence. Therefore, now if you will consume the time of the court, we will impose the cost.
I will
Which
go
will
to
keep on
my
increasing.
lordship.
Take down. This public interest litigation has been filed, seeking following relief. The petitioner, who is said to be a social activist, has challenged the establishment of the petrol pump by the which respondent? 16th respondent. On the ground that it is adjacent to the school, namely, what is the name of the school?
Mother Teresa,
Where you have mentioned? Paragraph?
Paragraph, Lord, I'll just. Lord, paragraph 3, my lord. Lordship.
Last time.
Mother
line.
Teresa High School.
Right next to it.
And as such, contrary to the guidelines, page
Page 36. I'm sorry, 46.
Hmm?
The guidelines start at page 39, my lord. Annexure E. And the relevant portion, your lordship will find it at page 46.
Set them right next to the school. Next to the school, they want to set up means share the same compound.
contrary to the guidelines for setting up of new petrol pumps issued by, who has issued these guidelines?
Central Pollution Control Board.
Central Pollution Control Board.
Please.
Para. Neither the school authorities nor the parents of the children studying in that school have come forward to raise the grievance regarding the establishment of the said petrol pump right across the school, and thereby putting any danger to the children. The anxiety of the petitioner to approach the court is not understandable. We do not find any reason to grant indulgence. It is for the oil company and the district authorities who grants the permission to establish the petrol pump to ensure to adhere to the guidelines issued in this regard. The writ petition is dismissed.
Serial number 21, I appear for the petitioner. The same question, my lord, in WP 1358 of 2022, my lords were pleased to issue notice and directed it to be listed on 2nd of March 2022, my lord.
Shall we
1358.
connect with
Yes,
this?
my lord. My humble request is to
On
connect.
the request of counsel for the petitioner, list along with writ petition number 1350 of
58, my lord, my
58 of
2022.
22.
Notice was issued there also. May I take notice to the learned government
Let
advocate?
it come along with that, then only we can issue the notice.
Lord, the same question, if your lordship would permit me, I will.
We will examine only then we can issue the notice. No?
I thought it was issued in that, therefore it can be.
All right. Already notice is already issued in that. It will be taken along with that, and if necessary, notice will also be issued in this.
Very well.
I appear for the petitioner in this matter, my lords. For the petitioner. In this petition, my lords, I have sought for a direction for the third respondent deputy commissioner to issue a challan for payment on my application and a subsequent consequent relief of deemed conversion. I had made an application, a representation on 30/11/21 to the third respondent deputy commissioner to issue an order of deemed conversion along with a DD enclosing the fine amount for rupees 33,000. Despite of having lost sufficient time, the DD deemed conversion has not been issued as on date, my lord.
Section 95(9).
My
Under
lord,
section
90, yes, my lord. Section 95 subclass 9.
Yes, what do you say? Very easily given up.
He has paid the fine before intimation. That is the only issue. That is, he is supposed to intimate the fine amount. Under 107.
The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that though the petitioner is ready and willing to make payment of the conversion fine, the same is not being collected and the deemed conversion order not being granted by the authorities concerned. S.S. Mahindra, learned AGA, taken notice for the respondents, submit that the request of the petitioner would be considered in a period of 4 weeks from the date of receipt of the certified copy of the order. In view of the above, a mandamus is issued directing
Difference in fine amount, if any, will be intimated to the.
directing third respondent, Deputy Commissioner, to intimate the petitioner the conversion fine amount required to be paid within a period of 4 weeks from today, and thereafter, on collection of the said conversion fine, to issue the deemed conversion order in terms of subclause 9 of section 95 of the Karnataka Land Revenue Act.
Appearing on the petition in this matter, my lords. This is a matter, my lords, wherein the Pollution Control Board, the fourth respondent, had given permission to the fifth respondent to consent for establishment of a fish meat processing unit, my lords. Actually, there are three categories of classification, my lords: red, orange, and green. Red has maximum restrictions, orange has some restrictions, green is clear, my lords. Actually, this was given under the green category, whereas it falls under orange category, my lords, without any restrictions. Green means without any restrictions, orange is under restrictions. It's an appealable order, my lords, but under section 31, but since the appellate authority is not constituted, I am before my lords. Under section 31 of the Air Prevention Act, I have to go before the appellate authority, my lords, any aggrieved person. But since the authority is not there, I am appearing before my lordships.
This is public interest.
No, my lords, actually, it is not because it's an appealable order, it is not covered under PIL, my lords. I went before the NGT. NGT referred me to this honorable court, my lords.
Who are you?
I am a villager, my lords.
How you are concerned about it?
No, because the water, this is a water level, my lords. Why happens? Because restrictions are not there. The effluents will be discharged directly into the stream, my lords. Whereas in the orange zone, there are ETP has to be provided, all those things are there, my lords. When it is given as the green zone, I produced the other mysteries are given for a similar purpose. Also, I produced, my lords, where it is calibrated orange category.
How
And even
is maintainable, Mister? How the writ petition would be maintainable?
No, because the appellate authority is not functioning, my lords.
You could not have filed the appeal also.
No, any section 31, my lords, any aggrieved person, it says. Section 31 of the Act says.
For show that you are an aggrieved person, give the. For show that you will be covered under the aggrieved person. You cannot file the appeal also. You are totally an outsider. Go and file a complaint. That's all. That liberty we can give you.
I appear for the pollution.
Because no, I am from the same village.
Mr. Chaudhary, writ petition is maintainable or not?
The writ petition is not maintainable, my lords, for the fact that one, there's an appellate remedy, and even if the appellate remedy is not available, my lords, he is yet to display as to how he is personally aggrieved by it.
Can he file the appeal?
He cannot file the appeal, my lords. As of today, he does not have any document to show that he is personally aggrieved by that, my lords. But in any grievance,
Petitioner is a resident of Kolsuru and is a public person and no connection with it. So therefore, it is not an agreed person.
Sorry, nothing can be done in here. This writ petition has been filed. Challenging the consent for establishment passed by fourth respondent as contained in action number A. Give the date and the petitioner is said to be the resident of the village where the respondent number 5 want to establish the fish freezing plant, in brackets surmi fish, in the industrial area of Pitrodi in Udaivara, Udupi, district Udupi. The counsel for the petitioner has not been able to satisfy the court as to how he is aggrieved party and how the writ petition is maintainable against the impugned order. The counsel for respondent number 2 to 4 has raised preliminary objection regarding maintainability of the writ petition on the ground that the order impugned is appealable, and secondly, the petitioner is not an aggrieved person. We are satisfied that in the given facts and circumstances, the writ petition on behalf of the petitioner is not maintainable. It is accordingly dismissed.
That's a request. I need to be shown respondent number 4.
For respondent 2 to 4.
I sought for an explanation from the concerned DC.
Eh?
I sought for an explanation from the concerned DC. I have produced that letter written by the DC along with memo dated 9/2/2022. The issue is not.
You will take the action on your own, or shall we direct?
May persuade your lordship. Your lordship may kindly come to page number 4, the translated version of.
You are with the petitioner or defending the officers?
I am not defending what is stated in the letter. I am not persuading your lordship. But as on the date of granting no objection by the DC Lord, in fact, he made inquiries. All the records mentioned in page number 5, 1 to 8, clearly reveals blood. As on that day, it is Gopal or Pullugani. It is stated in the revenue record.
What is your stand? Whether it is a Gomal land or the forest land?
It was notified. There is no dispute about that. It was a notified.
We don't want to know notified or not. What is your stand? That is we want to know.
It is a forest. It is a forest.
Then if it is a forest land, then whether it could have been leased out. Very specific questions we are putting to you.
No.
That it is a forest land. Yes. It could not have been notified, leased out. Now, knowing that it is a forest land and it could not have been leased out, in spite of that, it was leased out. And after you coming to know about it, why no action has been taken against the authority concerned, person concerned?
May I answer? This fact was notified by the Revenue Department only in the year 2005. Immediately thereafter, we have issued notices, and all the revenue records are mutated in the name of forest. And in fact, we have issued notice to the.
No, you are very fair. You are very fair. Your officers are very fair. We are not saying anything. We only want to know when the land could not have been given on lease, and in spite of that, it was given on lease. Then after knowing that, what action has been taken, why we should not order for CBI inquiry in such a matter. And for that, you were granted time on the last date.
It was a bona fide mistake on the part of the Deputy Commissioner because it was notified in the year 1904.
Thereafter, what you have done, that is also all bona fide. Even thereafter, whatever has been done, that is all bona fide.
Justifying my submission is 1904 notification was not the notice of the Revenue Department by the Forest Department. That is a mistake. That is why only when it came to.
So who is at fault, the Forest Department or the Revenue Department?
I appeal for both of them.
Eh?
You did not even ask the forest department. You certified that it's not forest land without even asking.
We will order for CBI inquiry in this case.
Yeah, assist the court on just two counts. One, to address His Lordship's question about why the forest department was not consulted. At that time, there was no statute.
No requirement. There was no
That's
requirement.
one. But even otherwise, there is no prohibition even today for forest lands to be leased. So to that extent, the state government technically was not wrong. But where possibly there is a mistake is that no mining activity should have been permitted without Section 2 clearance. Now, in this case, no activity has actually happened. Actually, nothing has happened. But and also, the letter that was filed before your lords, before my lords today, in fact, fortifies if my lords recollects on the last date. My only request was this: that let me be notified what exactly is forest land. If there is a part of my leased area that is forest land, I am statutorily bound to get a Section 2 clearance from the central government. My lords may record my submission that I am ready to do it even today. But once again, my lords, today's submission fortifies my stand that even the government doesn't exactly seem to know what part of my extent is forest land. Now, in fact, my lords, if only to, I won't take more than 2 minutes. If my lords were to see,
No, we will also like to know your who's who, that way you are connected, how you are connected, how you got the forest land on lease. That it is not simple thing. Must be under some influence, something behind.
If it is a forest land,
for a matter, my lords have successfully brought the state and the petitioner arguing in unison for once.
Some big person, somebody must be involved in this.
No mining activities had been conducted right from 2003 is my instruction. It's a last lease. That is why we have issued a notice which is under challenge. It is only a shortest notice.
No, what is the notice? That is very interesting.
We have issued a notice stating
Yes.
that your lease is defunct. Therefore, we treat it as a last lease. Please explain as to why it should
Because you have not carried out any activities. You are not saying that it is a forest land. No activity could have been carried out. You have issued the notice because you have not carried out any activity, and therefore it is stand lapsed. That is also very interesting.
I request my lords indulgence just to look at two documents.
Therefore, we are.
If I could request my
You have
lords.
violated the terms of the lease. We do not have such short memory. We also remember few things. So without seeing the file, we are telling you.
If I may suggest a possible way out of this, if I may suggest. In the letter filed along with the memo today, there are references to two survey numbers which according to the revenue DC was intimated by the forest department to be forest land. Now,
First, let them hold an inquiry let them fix the responsibility for this wrong done, and let them come out with the proposal to punish the guilty persons. Only then, otherwise we will first order for inquiry. And you know, when we will order for inquiry, what will happen?
Request is that blood, it is a bona fide, it appears that it is a bona fide.
All right, then we will order for inquiry. Then we will order for inquiry. Take down.
Record my submission to this extent that right from day one, yes, the lease was given to us, I bow down to my lord's views on why I'm not commenting on that. But this whole controversy began while a letter dated 30th of January 2010, where the Forest Department writes to the Department of Mines and Geology, mentioning two survey numbers. That's the undisputed fact. Survey numbers 12 and 14. Even today, my lords, when this letter is filed before my lords, there is only a reference to serial numbers 11 and 18, and in passing serial number 12. 14 once again is not mentioned, which, my lords, in one sentence, this fortifies the petitioner's standard. Please inform me what is forest land. If you tell me serial number 12 and 14 are forest land, I am statutorily bound to get a forest clearance under section 2. Without which, yes, my lords, I'm in complete agreement. I cannot.
You are not at fault. We are not holding you guilty.
If my lords is directing an inquiry, could the state also be directed to
They don't understand what can be done. We had given them chance. They don't understand. They think that whatever they have done is under bona fide. So we will make them realize what is right, what is wrong. So we had given them a chance to rectify themselves, improve their working. But
We will rectify ourselves, not that is what the DC has submitted.
I may be free to put some words into the government's mouth. Let them, if Mr. Maida could consider making a submission that yes, they will inquire into whatever your lordship has suggested, while also inquiring into the status of the land. Let them
Principal
give me a
Secretary को
certificate.
भी order कर सकते
The entire thing is
हैं.
forest land.
Send the matter to the Chief Secretary or Principal.
One last suggestion, possibly, in fact, I'm grateful to my instructing council. Your lordships recollects the order in that deemed forest is, of course, this is not a deemed forest issue. But if my lords recollects, the conclusion reached by the coordinate bench in that was to apply their mind to every application, find out whether that land is forest land or not. Maybe possibly, my lords, the state government officials could be directed to do that.
This is what we have asked the specific questions. They stand is that it is a forest land. Lease cannot be granted in forest land.
But the only thing is they're speaking in two voices. Forest department says survey numbers 12 and 14. Revenue department says 11 and 18. So there again, admittedly, as per this letter also there is.
We therefore have given time to them, and after instruction, learned AGA is saying on our query.
Page number 6, we have clearly stated it's a forest land.
Serial number 12, but 14
In
is
page number 6 of the letter, we have clearly stated that it is a forest land. It is not.
So now we will not decide whether it is a forest land or a revenue land.
Even all the revenue records are mutated now. Now in the name of forest department. You'll ask me kindly peruse page number 6.
What we propose to do is that we will send this matter to the Chief Secretary to hold an inquiry. And in all such matters where such lapse has been done by the department, hold an inquiry and submit the report. We will not direct for inquiry by ourselves. Let's see what the state government does. All right. First up, heard. Counsel for the petitioner as well as the AGA. The writ petition has been filed seeking following relief. As per the case of the petitioner, mining lease was executed in its favor on 4/2/2002 with respect to land bearing at survey number 10, 12, 13, 14, 15, 17/2, 18 and 19, measuring 525 acres in Kenkeri village, Hosadurga Taluk, Chitradurga district. Full stop. On 30th of January 2010, respondent number 5, Deputy Conservator of Forest, sought for suspension of mining activities in the areas till permission under Forest Protection Act 1980 is obtained on the ground that the lease area falls under the Jankal Reserve Forest.
Survey number of the lease data. 12 and 14.
As the survey number 12 and 14 falls under Jankal Reserve Forest. Learned Counsel for the petitioner contends that Deputy Commissioner Chitradurga District, by letter dated 21st of March 2001, had informed that the land in question is Kharab and barren land, and it does not belong to Forest Department. The Assistant Commissioner in his report has stated that mining permit can be issued for the said lands, and therefore he has no objection for granting mining lease in respect of the said lands. It is submitted that at the time when the lease was granted, there was no requirement for NOC from the Forest Department. Learned Counsel for the petitioner wants a joint survey to be conducted in order to ascertain as to whether the said lands are revenue lands or forest lands. The same request has also been made by the Office of the Director of Mines and Geology Department. Full stop. The question before us is how the land in question, which are undisputedly notified as forest lands, could have been given on lease for mining purpose, and what action has been taken against the hearing authorities who had granted the lease without making proper inquiry and without involving the Forest Department. Full stop. It is a matter of concern as to why no action has been taken till date, even after the said facts have been brought to the knowledge of the authorities concerned, and how impugned show cause notice dated 10/6/2019 was issued calling upon the petitioners to explain as to why it shall not be recommended for declaring it as the lapsed lease, as the petitioner has not exploited the land in question for mining purpose and kept the lease idle. From the perusal of the impugned show cause notice dated 10/6/2019, it appears that the Geology and Mining Department is still treating it to be a land which could have been granted on lease. And since the land has not been exploited for mining purpose, and therefore the lease should be treated as lapsed. Full stop. On the last date, we had granted time to the additional government advocate to seek instruction in the matter. He was also required to make a submission as to why inquiry may not be ordered in this case by an independent authority. Full stop. Para. Today, when the case is taken up, learned AGA on the basis of instructions inform that the land in question on which the lease was granted is forest land. It is also informed that the said land which belonged to forest department could not have been granted on lease. However, the fact remains that the lease was granted over the land in question, that too without involving the forest department, and the said mistake was not corrected in time. The Geology and Mining Department is still treating the land in question as the land which can be granted, could be granted for mining purpose. Full stop. In this view of the matter, we feel it appropriate that a thorough inquiry shall be held and the guilty persons shall be brought to books. Full stop. We therefore refer the matter to the Chief Secretary, Government of Karnataka, to pass appropriate orders instituting inquiry in the matter by a senior officer not below the rank of secretary to the principal secretary of the secretary to secretary, Government of Karnataka, and full stop. The inquiry shall be completed in a time-bound manner, and the inquiry shall be held with respect to all such matters where the mining has been permitted on the forest land or any other land which is not permissible for mining purpose. The inquiry report shall be placed before the court. Full stop. Listed after 6 weeks.
31-3.
These are final hearing.
My lord, I appear for the respondent number 1 in this case.
Yes.
My lord, I had filed the memo of appearance on behalf of the Ministry of Environment and Forest. And learned ASG was appearing in this case, my lord, Shashikant. And since he has been relieved, my lord, I had filed the memo of appearance, my lord. Let my name be displayed there, my lord. Directions may be given.
List again. showing name of
Shivakumar.
give the date. Next.
Much obliged.
Pursuant to the last order, we have filed the amended petition. However, there was one error that has crept into it where one of the respondents was left out. And if we granted 1 week's time, I'll rectify that amended petition as well.
Agent on the request of counsel for the petitioner, give a date.
This is a matter which, the last occasion, my lord, we had a submission regarding filing an application for extension of time, payment of 50% of the amount, in order to stay the execution proceedings in the arbitration proceedings. There's an order passed by the from the court, my lord, on
Asking for extension, then he said he doesn't trust.
No time left now.
The application, if he doesn't press, then that will be discussed.
Awesome.
Oh, the application you want to press, Mr. Rajesh?
Lord, if I'm granted 4 weeks, I can make the payment, my lord.
On the last date, you said you don't want to press the application.
I asked the client, because I mentioned to him that this matter is a decree. I said it will inure to the benefit of even the respondent, my lord, if I'm able to deposit, then whatever the outcome, if I fail in the appeal, he has access to that money, my lord. I will, if my lord please grant me 4 weeks time, I can deposit, my lord, because of COVID.
2 weeks time. We grant you 2 weeks time to deposit.
Fortunately, my lord, practically, I don't want to make a submission. We will not be able to make that payment. I mean,
2 weeks we are granting.
Construction company, my lord, we are going hand to mouth with loans. That's why I'm saying.
It's a hotel as well as construction company.
Hotels are empty, my lord, because of COVID.
And to show that.
I need to argue the main appeal, my lord. My lord, I'm ready to argue even the main appeal. I believe, my lord, I have a good case. Even the main appeal, I can argue any date, my lord.
We'll have it again then.
You'll have it again, but this your extension will not be there.
We'll reject it. We'll fix it for hearing.
So let it be kept pending, my lord. I won't press it. Any date, early date for final hearing, my lord, then I will convince my lord that that award should be set aside.
Now, he has been seeking time in the execution side, saying that he would comply with the order.
Next week,
No, I mean, what my learned friend is saying orally, I cannot respond, my lord. My lord, I filed as per the directions of this honorable court. I filed written submissions.
All right.
6 for 1 more week's time. Is this done?
March. Complaint of into order, extension is granted. Number 88.
Lords, I beg to appear as the amicus. Lords, this matter pertains to the special courts for MPs and MLAs. Lordships had directed it to be listed on 17/1, my lords. It did not appear in the list. So Lordships may be pleased to post it, my lords, at some date convenient.
Third on IA1 of list on. Give it a
5th March.
Please. Grateful.
29.
29 got agenda. Okay,
I'm sorry, 5th March is a Saturday, my lords. If I heard the court.
It is working. The senior advocate don't come.
Please, no, I'll be there, my lords.